Good afternoon, everyone. My name is Whitney O'Reilly. I run our wealth preservation department here at Cohen-Seglius. I know we're about a minute from getting started, so I'll wait just a second as people are piling in so that nobody misses anything. One of the things that I'll say as you enter, and I'll keep repeating, is if you have any questions through this hour-long presentation, please put them in the Q&A section. I will certainly try my best to answer them during this webinar. If there's something that's either off topic or I think it would be better to email you separately, I get a list of those questions thereafter, so I'll certainly send you some information. But just use that question and answer section. Again, as people roll in, today we're going to talk about living wills, a bright, beautiful day where we're going to talk about death and dying. So let me just turn off reminders so we don't have any background noise. Okay, and it looks like people are piling in. We're probably going to wait about 1 or 2 more minutes so that we can get everybody in here, and then we can get started. It's wonderful to see everybody back. For everybody who hasn't been here before, I normally do a monthly lunch and learn where we talk about something estate planning, estate administration, trust related. My name is Whitney O'Reilly, and I run our wealth preservation department here at Cohen-Seglius. We service a number of states here in the Northeast: Pennsylvania, New Jersey, Delaware, New York, DC, Maryland, Virginia, even Kentucky. So we are a growing law firm. We have about 100 attorneys now, and we have a growing wealth preservation department. Oh God, it's 12:01. It looks like there's still some more people piling in. Just remember, if you have any questions through this presentation, plop them right into the question and answer section. I'll do my best to either incorporate those answers into the things that we talk about, or if I think it would be better to separately talk to you, I'll shoot you an email afterwards. Today, I don't have slides. We're just going to have a conversation today. But if you need anything, certainly you can find me on the internet. My name is Whitney O'Reilly. Our law firm is Cohen-Seglius. You can look up my contact information, give our law firm a call, shoot me an email. Happy to answer any questions you may have at any time. So without further ado, I think the participants strolling in looks like it's slowing down. It's a little past 12 o'clock, so let's get started. So again, my name's Whitney O'Reilly. I run our wealth preservation department here at Cohen-Seglius. I have been practicing in the field of estates and trust for the last 15 years. So I have a lot of experience when it comes to estate planning, estate administration, trust planning, and trust administration, including what we're going to talk about today, which is a living will. Now, remember, as we start talking about this, sometimes living wills are called advanced directives. Sometimes a medical power of attorney is called a healthcare power of attorney or a healthcare surrogate designation. And then please remember, today I'm going to talk generally about the history of living wills here in the United States. I'm going to sprinkle in some Pennsylvania laws, but just remember, if you're in one of the other states we practice in, or if you're just listening from another state completely, remember that every state's laws are different that are applied to the estate world. So we have the federal law that overlaps all of the state laws, and then we have specific state laws that have specific rules and regulations that guide these kind of legal documents. So for instance, in Pennsylvania, someone who is considered terminally ill, there's not a timeline, as in you could be terminally ill and still be alive for a couple of years. You can be terminally ill and pass away in a few weeks. In New Jersey, there's an exact time. So that's important to understand these legislation components so that we can figure out the best way to draft your living will for you to understand your living will and that living will to work the best way that it possibly can. So let's talk a little bit about the history of living wills. Where do these things come from? And let's sort of start back with every one of you who are on this should have an estate plan. And an estate plan includes a last will and testament or revocable trust. That's the document that says what happens with your things when you're not here anymore. But another vital component of an estate plan are these power of attorneys and living wills. So I feel that they're often overlooked. People think they're boilerplate language or check the box something, and they're just an add-on to this really sophisticated document system over here. And the answer is these documents are the ones that really come into play while you're still alive. So they're as important, if not more important, to have them the way that they should be so that they legally work and they work the way we want them to when we've got the right people in place. So we've got a financial power of attorney. We're not going to talk about that today or the legislation regarding that, but that's when somebody steps in and makes financial decisions for you. Then we've got the medical power of attorney, again, also called the healthcare directive. That's allowing somebody to make medical decisions for you if you can't make them or choose not to make them for yourself. And then there's the living will, or that advance directive, sometimes also comes with an organ donation component. So that makes up your estate plan for what happens when you can't make your own decisions during your lifetime, who gets to help you make those decisions, and then what happens after you pass away. So again, the history of living wills, we didn't always have living wills or the ability to utilize living wills here in the United States. That didn't come into play until the 1960s. So Louis Kutner, who was a notable human rights attorney, he was from Chicago. He had a very close friend who had a terminal illness, and he watched that friend suffer slowly over a period of time and continue to not say no to medical treatment. And so he advocated for a document so that people could express their wishes who were nearing death. And thereafter, we tried to pass regulations. So in 1968, in 1973, and it didn't work. It didn't fly. Here in the United States, we said, no, a person, and you can't nominate another person, and you can't choose either to not receive medical treatment. You're going to receive all treatment. And then in the 70s, we had Barry Keene, who had a terminally ill mother who wanted to refuse treatment, and even with a medical power of attorney, was not able to tell the hospital, stop treating this person. So finally, in 1976, California was the first state to allow living wills. By 1992, all states here in the United States have living will legislation. We also have a federal law that came out in 1990 that federally allows this living will legislation. And so in 1976, this is really where it got started. We started to think about it in the 60s. In the 70s, it took hold. And there's really three pivotal cases that I want to talk about today that really shaped our living wills here in the United States and here right now in Pennsylvania, although I'd say many other states as well. So the first case that we're going to talk about is Karen Ann Quinlan, and this happened in 1976. So she was 21 years old. She went to a party. She drank heavily. She popped some Valium pills and passed out. She was revived, but she had not been breathing for at least 5 minutes, and she was in a persistent vegetative state. Her father, after a period of time, wanted to allow life support to be turned off. The hospital would not allow that. So this went through the court system. And basically what happened was this court sets the precedence for the ability to appoint a healthcare proxy, somebody to make those decisions for you. And we're going to stop right here because a lot of my clients, when we get to a medical power of attorney and a living will, they say, what's the difference? They're the same thing or they're interchangeable. And the answer is not. They're two very separate documents. decisions. They do work together, but they're separate. So a medical power of attorney or healthcare power of attorney is where you're saying, if I can't make my own decisions, if I have COVID and I'm on a ventilator and I can't say what treatment I do or do not want, then I want my spouse to make those decisions. That's who I have in my medical power of attorney. If my spouse can't make those decisions, I want my mom to make those decisions. So she's going to make all those decisions. She's going to have a HIPAA authorization that allows her to access my medical records so that she can make the most informed decisions possible about my health. I don't want a court making that decision. Like here in Quinlan, I don't want a court to tell my family whether or not I can or cannot have certain kinds of treatments. Ahead of time, I want to say, nope, that's going to be my decision. And if it's not my decision, it's my husband's decision. And if it's not my husband's decision, it's my mom's decision. And it has certain powers throughout that document. Now, in my medical power of attorney, I do say I have a living will, and please look to that living will medical power of attorney for guidance. And so now we get to this living will that says what you do or you don't want at the very end stages of your life. And that'll sort of move me to the second case. Now, this is a Supreme Court case called the Quinlan versus Director of Missouri Department. And this came out in 1990. And basically Nancy Quinlan, she was 26. She got into a car accident. She was found laying face down in a ditch, covered in dirt. She hadn't breathed for at least 8 minutes, but CPR brought her back. She was in something like a persistent vegetative state. She had no cognitive functioning, but she did have some motor reflexes. So again, here the family wanted to allow her to die a natural death, to turn off those life-sustaining treatments, and the hospital said no. Here in this case, we even have evidence in the court case where a roommate said, we had a discussion about this, and she'd say, I never want to be kept in a persistent vegetative state for a long period of time. And basically the court said, that's not enough. That doesn't count as clear and convincing evidence for us in order to let her die a natural death. So basically, Quinlan is the case, the Supreme Court case that really sealed the deal for living wills, that said everybody needs to have clear and convincing evidence of what they do and they don't want at the very end stages of their life. So it validated the use of these living will vehicles. So moving sort of to the legislation, because of that case, it really created the Federal Self-Determination Act in 1990, often called the PSD. It is updated from time to time, so we always need to be apprised of the changes in that law. But that's a federal law, and it requires written information regarding patients' rights under state law to make decisions regarding their medical care, including these advanced directives. It also says that we can't condition or discriminate based on a person's advance directive, that we have to comply with a patient's advance directive consistent with state law, and we must note on patient records if they have an advance directive, and we have to educate patients on the ability for people to have an advance directive. So if you've ever gone to a hospital, you've experienced this, which is before you go into surgery, they're going to say, do you have an estate plan that includes a living will or advance directive? And you'll answer that question. Hopefully after this webinar, you'll reach out to your attorney, you'll print something out from online, and you'll have a living will where you can say, yes, I do have a living will. So if I meet the criteria in that living will, it's okay to let me die a natural death. I don't want to be a Cruzen. I don't want to be a Quinlan. And then we get to the third case that I wanted to talk about, which is the Terry Shivo case. A lot of us know this because this happened in the late 90s. The decision wasn't until, I want to say, 2006, so not that long ago. We had a woman who had battled with her weight, like many women do, for the majority of her life. She was 25, I want to say, and may have been bulimic. So wasn't eating a lot. And when she was eating, was getting rid of things. She was on some kind of, I feel like, a diet where she only drank liquids, which I think probably impacted her potassium levels, which led to her passing out. Where she was not able to be revived for, again, a number of minutes. She was determined to be in a persistent vegetative state. Of course, she didn't have a living will. So her husband went through the court system. So if you don't have an estate plan that includes a medical power of attorney and a living will, and we need to make decisions, someone needs to make decisions for you moving forward. If you don't have a medical power of attorney, if you don't have a living will, you've got to hire someone like me. You could do it yourself, but most people would hire an attorney to get something called a guardianship. There's a guardianship of the estate and there's a guardianship of the person. So guardianship of the person deals with these medical decisions. Guardianship of the estate deals with financial decisions. Well, that costs a lot of money, takes a lot of time, and again, is giving the court the ability to make the decision on what happens with you versus a family member. And even in that Cruzen, that Supreme Court case from the 1970s, the court system said these kind of questions should be answered. The onus should get to be on this person and their family or their loved ones to answer those questions. It shouldn't be the court making those determinations. So the court system was advocating to have these medical power of attorneys and living wills for us. Well, fast forward, we've got Terry Shivo. She didn't draft a living will. And when she passed away, she had a husband and both of her parents still living. She didn't have any children. So her husband, after a period of time trying to rehabilitate her to find out whether or not she was truly brain dead, after spending enough time and getting enough diagnoses that she truly was in a persistent vegetative state, asked to pull out her feeding tube. Her parents didn't believe she was really in a persistent vegetative state. And those twitches that sometimes happen when somebody is in a coma or persistent vegetative state, they believe meant that she was still there in some capacity mentally. So who gets to make that determination? And the answer is, if you don't have a medical power of attorney and you don't have a living will, the court system is going to make that determination. So the court system allowed the husband to make those decisions. And unfortunately, the parents continue to appeal this case where Terry Shivo, living in a persistent vegetative state for nearly 16 years, until the husband was finally allowed to remove the feeding tube, and thereafter she passed away shortly thereafter. So that's really the third case. We have that first case that says that it's okay, we can name a healthcare advocate. And then we've got the second case that says, yes, living wills are binding on the court system. And then we've got this third case that says we need to have a living will in place. Otherwise, we're going to wind up being in a persistent vegetative state for a long period of time. I do know I looked into this case and they did do an autopsy of Terry Shivo to see how much brain functioning she may or may not have actually had. And her brain had shrunken to over, it was at least a half, if not more, shrunken smaller than it had started. And there was no brain functioning. So that sort of leads me to, that's the history, that's the case law of these living wills. We've got that federal law. We've got the Federal Self-Determination Act of 1990. Again, Pennsylvania, like most states, has laws as well. Here in Pennsylvania, it's the Advanced Directive for Healthcare Act, and that was codified in Pennsylvania legislation. Here in Pennsylvania, we nickname it the PEF code. That's the Pennsylvania Estates and Fiduciaries Code. That's a regulatory guideline for everything in the estate world. And Chapter 54 relates to healthcare, power of attorneys, and living wills. So that legislation offers immunity to providers so that providers are willing to accept these living wills. It gives you the requirements of what you need in order to execute a living will. And we'll sort of stop and say, what do you need to execute a living will? Well, here in Pennsylvania, anyway, you need someone who's either over 18, someone who's married, or an emancipated minor. They need to sign it, or they can sign by mark. And so sometimes that happens in the legal world when I'm working with someone very, very sick. They never got around to doing the estate plan. They still have all their faculties, but they can't use their hands anymore. They can sign by mark, but there's some additional requirements to that. And that document has to be signed in front of 2 witnesses, and that individual has to be competent. So what does competent mean? That means, let me just pull it back to here. Competent means that you understand the risk and consequences of your choice and that you're able to communicate those back. So as long as you meet those requirements here in Pennsylvania, that's all you need. Some people will ask me, wait a minute, Whitney, don't you need a notary? You don't need a notary for a living will. You do need a notary for a financial power of attorney. Although years ago, you didn't need one for a financial power of attorney either. That's a pretty new piece of legislation. But best practice, at least for me, is signed in front of 2 witnesses and a notary. So how does this document actually come into play? How does it get utilized? Well, it gets utilized, one, when you give it to a doctor. Somebody needs to have this document in order for it to be facilitated. The doctor has to say that you're incompetent, that you're not able to make those decisions, and that at least here in Pennsylvania, you either have to be permanently unconscious or you have to be permanently unconscious or terminally ill. So some other states have some other requirements. We already talked about that there wasn't a time constraint to that for here in Pennsylvania. And again, in order to be incompetent, you can't understand the risks and benefits of alternatives. You can't make your own decisions, and you can't communicate as a decision maker. So that would be incompetent. So again, that's a living will. It's pretty simple. And I'm actually going to share my screen with you right now. Well, yeah, I'm going to share my screen with you, and I'm actually going to show you here in Pennsylvania, we have a statutorily constructed living will that's right inside of the Pennsylvania's estate and fiduciary codes. And I want to take us through it here today so that you can see what a living will actually looks like and the decisions that you have to make. So I'm going to share my screen here. And I'm going to pull up Pennsylvania's Title 20 PEF Code Chapter 54 Healthcare. So we're going to go all the way down. I'm going to sort of gently scroll through here so everybody can see this is the legislation that guides the drafting and execution of these documents. And again, we've got a default set of rules here in Pennsylvania, but we don't want those default set of rules. We want to make our own decisions. Now, here we actually get to pregnancy. This is a really interesting one. In a living will, you can say no to any life-sustaining treatment, but if you're pregnant, you can't actually say no. They are allowed to keep you alive until the fetus is born. There isn't anything in the law that says they have to do a pregnancy test. But if they know you're pregnant, they have to keep you alive. There are a couple exceptions to that. If the measures will result One, we have to make sure that the measures wouldn't result in a live birth of a fetus. If the baby's not going to live, then the living will could be utilized. If the treatment would be more harmful to the woman, we don't have to keep that woman alive. And if the treatment causes her pain that can't be fixed with medical treatments, then again, we can allow that living will. But that's important to know as somebody who could be pregnant. We've drafted this living will, we've got this living will in place. Why is the hospital not accepting this document? Well, one, we have a piece of legislation that says if you're pregnant, we can't end your life, at least not for a period of time. And so let me get all the way down here. So now we're at living wills. Again, we already talked about what makes it operative. You have to be 18 or have graduated from high school or have married or have been an emancipated minor. And that you have to sign it in front of 2 witnesses. I like that it is notarized as well. And again, when is it operative? When can we use it? A copy has to be provided to the doctor, and the principal has to be incompetent and has to be in an end stage medical condition or permanently incompetent, permanently unconscious. So again, we've got what happens if we don't have a living will. We already talked about that. We're going to wind up through the court system like Terry Shivo on life support for 15 years. We certainly do not want that. So let's get down here to an actual living will. Hopefully everybody on this webinar has a living will and is just learning a little bit about the history, the case law that has come into place. And now that we look at a living will, what should my living will have in it? I didn't realize I should have a medical power of attorney as well. I need that medical power of attorney to make all of my decisions. And you'll see here, we get the combined form. Now, this is just Pennsylvania, not another state. Not all states have a statutory prescribed document. And certainly most practitioners don't want to use just the statutory form. We're bringing things from cases, we're bringing things from regulations in order to make this document work as best as it possibly can. But here we go. We've got a healthcare power of attorney that says, I'm picking somebody to make my medical decisions if I can't make those decisions. They've got that HIPAA authorization, and I'm giving them guidance through this next document, which is my living will, that says what I do or I don't want at the very end stage of my life. And so here we are. Healthcare treatment instructions in the event of end-stage medical condition or permanent unconsciousness. So here's Pennsylvania's attempt at a living will that says, if I'm in an end-stage medical condition, which will result in my death despite the introduction of the continuation of medical treatment, or I am permanently unconscious, such as an irreversible coma or an irreversible vegetative state, and there is no realistic hope of significant recovery, all of the following shall apply. And we'll look through those. Of course, we want something in the living will that says that you can have treatment to relieve pain. So most of us, and I don't know because I don't know all of you on this webinar, most of you would agree with that statement. I know for me anyway, in the 15 years I've been doing this and the thousands of clients that I've seen, most, if not all of my clients say, if I meet the condition that you just said, Whitney, I want to be able to die a natural death. I don't want to be kept on life support for 15 years until my brain shrivels into a tiny raisin and my body just gives up. That sounds like a horrible, horrible ending. And I want to make sure that that doesn't happen to me or to my clients. So this just says that all life-prolonging procedures will be withheld or withdrawn. We do have a place, at least in my kind of living will, where if you have a particular physician that you want to notify or be part of making that decision, we can list that as well. Doctors actually, under the federal legislation, and we've tried to update this, amend this from time to time, but doctors actually don't have to accept a living will under the federal laws. So they are allowed to say, no, I don't want to agree to turn things off, or My religious beliefs don't allow me to take a feeding tube or water out. But basically what they have to do is transfer your care to either a facility or a doctor who is willing to accept that. And then let's look at the different things that we want to talk about. If I meet that definition, so remember, if right now I'm so excited to be on this webinar, I've had a couple cups of coffee, I can't wait to tell you all a little bit about the knowledge that I have regarding living wills. So excited, my heart is beating so fast, I have a heart attack. Well, I have a living will that looks somewhat similar to this statutory construct here in Pennsylvania that says, I do not want CPR. Am I going to get CPR? Yes, because I don't meet that definition. But if I sit here and have a heart attack and I'm not resuscitated for 10 minutes and they are able to resuscitate me, then my living will kicks in and it says, if my heart goes again, please don't bring me back to still not be here. Let me die a natural death at that particular time. So you'll see all of these, and each living will can be slightly different, but we've got heart and lung resuscitation. We've got mechanical ventilation, that's a breathing machine. Dialysis, which you know is the kidney machine. Any kind of surgery, chemotherapy, radiation, antibiotics. And then here in Pennsylvania, anyway, you have to specifically say whether or not you want food and water. So you have to say if you want nutrition or if you want hydration. And if they're medically supplied by a tube into your nose, stomach, intestine, arteries, or veins, that if you have that end stage condition, then it's okay to take them out. That one, I don't want them, but if I have it, you can take that out. Something else that is really important is, and we'll get to this later, sometimes it's in like a part 3 of a living will. Part 1 is that healthcare power of attorney. And I'm actually going to stop here for a second and say, I don't think that you should have all of these combined. I like a separate medical power of attorney and a separate living will. I'm okay with the organ donation component being in that living will. But most of the time, I want treatment. I want life-sustaining treatment. So everybody can have that medical power of attorney if I can't make my own decisions. I really only want this living will taken out when and if I meet that definition. And at that time, my family members who have these documents can simply take them out and they can be followed. So again, there's an organ donation component. That was actually one of the most recent pieces of legislation here in Pennsylvania. That happened in 2019, 2018, that was Act 90. And so that updated the organ donation laws, at least here in Pennsylvania, that said, you can have a living will and you can say, donate my organs. But if you don't specifically say my composite, my vascularized, composite allografts, then you can't donate those specifically. So composite vascularized allografts. I should have said this in the very beginning of the webinar. It tends to keep everybody listening, but I love doing my monthly lunch and learns to have a particular trivia question. Today we have 2. So everybody who's only half listening, I'll say it really loudly, but you're about to get a prize. If you listen and get the answer correct, you can put it down in the question and answer section. The first one that I see correct, it's going to note it, and you're going to get a $50 gift card. So we'll do this right now, and we'll do this at the end as well. And so right now I'm going to ask you a question. So we were just talking about organ donation law, the updates to the law, which was this Act 90, which talked about vascularized composite allografts. Can anyone tell me what a vascularized composite allograft is? And I'm going to wait just a second to let some of you type something in. Or maybe nobody knows it. Maybe this first one, we won't get anyone who knows what vascularized composite allografts is. So we'll move on. So vascularized composite allografts, that's your hands, your face, and your feet. So in order to specifically donate those here in Pennsylvania, you have to specifically say it. So if you have a living will that's a couple years old, it's not going to include that. If you have a living will from a different state, you may not want that particular language in there. Here in Pennsylvania, pursuant to Act 169, that came out in 2006. Here in Pennsylvania, we allow living wills from other states. Most states have reciprocity, as in the documents that are drafted here, as long as they're legal here in this state, are able to be utilized there. But one of my suggestions to clients is, if you move to another state, get your documents updated so that they match with the legislation in that particular state. But here we get to organ donation, which is, are you an organ donor? Do you want to donate all of your body? Do you want to donate some of your body? Do you want to donate none of your body? Do you want to donate those vascularized composite allografts? So that's something we want in a living will as well. And then, how do we want this document to be utilized? Do we want every single word in this document to have to be adhered to by the medical power of attorney and wherever you are receiving that care? Or do we want it simply to be instruction for your medical power of attorney to facilitate the best possible decision at that particular time? That's a really important component piece to have in your living will. So there you've seen, I'm showing you the sort of the end of it. This is where you date and you sign it in front of two witnesses. And so here we've sort of glanced through a living will. I'm going to actually stop sharing my screen, and hopefully everybody can see me a little bit better. I think my screen was flashing maybe. Maybe it was just flashing to remind you that that you could win a prize. Don't worry, there's another chance a little bit further in to get a prize when we're talking about living wills. I'll sort of stop for a second and recap. So when we started this presentation today, we talked about the history of living wills, that before basically the 1970s, you couldn't even choose to stop having treatment if you were in an end stage condition. Then the laws were changed to say, you know what? Yeah, you should be able to say, I don't want treatment anymore at a certain point. And so in the 70s forward, we had a bunch of cases that started to allow someone else to help you make decisions without having to go through the court system and get a legal guardian, right? Remember that guardianship is also in other states called something else. For example, I don't know if you've seen the Free Britney documentary, but there in California, it's called a conservatorship. So again, it can have slightly different names, but it's all the same thing. Somebody else making decisions for you. And again, we had those three pivotal cases that sort of allowed us to designate a healthcare power of attorney, that allowed living wills to be binding, and that further showed that we need these living wills so that we don't wind up in court laying in a persistent vegetative state in a hospital while your family is in court for 15 years. These documents are really important. I want to actually show you, there was this article, I want to say my dad sent me maybe 6 months ago or a year. It was in the Philadelphia Inquirer, and someone was writing about living wills and whether or not they're really helpful. And it was a very interesting article, but very misguided. And what I mean by that is, I've been doing this for 15 years. I see lots of people at the end stages of their life. And when we do not have a living will, when we do not have a medical power of attorney, the family is going to spend tens of thousands of dollars going through the court system to try to figure out what to do. And even through that process, I don't know that we'll ever accomplish what that person actually wanted, because we can't ask them. Whereas if we have a medical power of attorney and we have a living will, we have a legal document in place that says what you do or you don't want in certain stages of your life. And it is only important. And I think some of the articles said, you know, it doesn't always account for every particular situation. And that is certainly the case. If you have a living will, I know my living will, when I first started drafting them, was less than a page. Now my living wills are sometimes 2 or 3 pages, depending on which state we're practicing in. Remember, we have about 7 states that our wealth preservation runs in, and some of these documents are statutorily specific and some are not. But it's gotten longer and longer because there are more situations that I am seeing as a practitioner that I want my clients to get to choose what the answer to that is. And again, this living will, even though it's the legal document, it's having that conversation with and about the living will, sitting down with your spouse, sitting down with your children and saying, these are the things I do or I don't want at the very end stage of my life. I am an organ donor. I am not an organ donor. If I donate my whole body, I won't be able to be buried or cremated. They'll take it. Am I okay with that? Am I not okay with that? When do I want to be allowed to die a natural death? There's always medical advances. Maybe I'm distrustful of the medical community and I want to be kept alive forever. Or I'm like that famous baseball player who wanted to be cryogenically frozen so that he could possibly be brought back or exist forever. It's important. We are each our own people, and we should get to make those very important decisions. Maybe we have a religious reason that we don't want to allow a feeding tube or hydration tube to be removed from our body. I will say part of the living will legislation here in the United States, we had many court cases in the beginning of this, that taking out a feeding tube and taking out hydration would be considered suicide. And most life insurance policies have a clause that say if you commit suicide or commit suicide in a certain period of time, you don't get those payouts. And so we had to create legislation that said that no, this is not suicide. This is making an end of life decision on how you want to end your life as it comes to a close. Again, this was part of that palliative care. So that's something that's very, very new, having to figure out how you want the end of your life to transition to whatever the next something is. And that living will helps give us that guidance, but it also helps us have conversations. Getting sick and dying is really difficult. It's really difficult on the person who's experiencing it. It's really difficult on the family members and friends who are involved. So having more information for them, having more things already put in place makes the process that much easier, so that instead of focusing on these things or trying to figure out what somebody wanted or working with an attorney and going through the court system, instead of doing those things, you can simply spend time together. I'm going to ask one more trivia question. Let's see if we can get it. If not, maybe I'll ask one a little bit further along. I know we only have about 15 more minutes. I'll stop for a second and say, does anyone who is on this webinar today have a question? A question about if a living will is valid? How is a living will utilized? What exactly is a living will? Hopefully I've answered all of those questions for you, but certainly feel free to ask a question and I will add it into the conversation. So what are the things that I see that happen with clients? So let me tell you a little bit. I've told you about some Supreme Court and high level cases that affect living wills here in the United States, but how about just my own experience in the last 15 years that I've been practicing? What I can tell you is if you have a medical power of attorney and a living will, an attorney will probably charge you, normally estate plans, I don't know, or anywhere between $200 to $4,500. And that would include that medical power of attorney, that financial power of attorney, that living will, that last will and testament, revocable trust. And I'm sort of just generically giving you a number. If you have those documents, the family never has to hire me to get a guardianship. A guardianship can cost tens of thousands of dollars. So that's one thing that I see people say, well, what does it matter? I'm not here anymore. So, what do I care if I'm out of it? And the answer is you care. It's your money. You've worked your whole life for it. You want to make sure it's there for your care. You want to make sure the people you want to be making decisions for you do. And that money, when you're not there anymore, goes to who you want it to. Another great question, and something I see, is I have a lot of people that have living wills, but they're never able to be utilized because people can't find them. And people often, especially if they try to do something online where they figure, you know what, I can save $1,500 and, I'll just print something out from online and I'll execute that. One, they're not executed correctly. Most of the time, they've never been signed. People print them out and think that they'll get around to executing them, and then they don't. And the family members bring those into me in an emergency-like setting and saying, here, we've got this living will. Is it good? And I simply look at it. It's not signed. It's not executed. It doesn't have any of the legal requirements in place, and we can't use it. Or I know they would have a living will, but I can't find it, or they're in a hospital-like setting and living will is not on their chart, and they keep resuscitating this person. What I can say is my answer changes over time for where you should keep a living will. When you're young and healthy, just let your family members, your friends, your doctors know that you have a living will and you can provide it when necessary. When you have, let's say, an end stage condition, as in you have stage 4 cancer, you were going to pass away, whether it's 2 weeks or 4 months from now, that's the time for everybody to have your living will. Maybe even I've got lots of clients that put it right on their refrigerator that says, I have a living will. If I am not breathing, please don't give me CPR so that I can be brought back in more pain for a small period of time. So that's really important, is where to keep it. There are some states that have state depositories where you can keep these documents. You could keep it in a safe deposit box. I think that's really wonky. It takes a while to get that document, and by then you're now on a feeding tube, and we don't know if we want to take that feeding tube back out. So I would say, just make sure that you've got those documents, your family and friends know them. I check them from time to time. Right now, I have the backup as my mom to make a medical decision for me. But someday when my children get older, it'll probably be one or both of my children making those decisions. So once in a while, you've got to look back at it. Again, legislation is constantly changing. Right now here in Pennsylvania, we've got a couple pieces of legislation that haven't gone through yet regarding the right to die. So I want to sort of separate this out in 3 different categories. We've got living wills, we've got right to die legislation, and we've got do not resuscitates. So we're talking a lot about living wills that says at the end of my life, it's okay to let me die if I meet these certain criteria. I don't want these things, but of course I want to have medicine to keep me comfortable at that very end stage. A do not resuscitate says, I don't care what condition I am in, do not give me CPR, don't bring me back. And sometimes people at the very end stage, when we have those stage 4 cancers, when we are going to pass away somewhat soon, we're going to have a living will and we might have a do not resuscitate. But someone like me, I would like to say I'm still young and healthy. I do not have a do not resuscitate. I want you to bring me back. I've got young kids that I want to see graduate high school, go to college and beyond. I have a business that I want to see, move into various other states here. I want to grow this wealth preservation department. Keep me here. But if I am like Terry Shivo, if I get on a diet because I'm watching one of those silly TikToks that my daughter watches on, drinking lemon water for 4 days, and I lose oxygen for 9 minutes and I'm in a persistent vegetative state, then I don't want to be kept like that for 15 years. I don't want to burden my family members, my friends. I don't want to live in that state till I die. I want to be allowed to then die, transition my life at that particular time. But then we've got this right to die. So at this time here in Pennsylvania, we don't have, it's called assisted suicide or right to die or physician assisted suicide. But here in Pennsylvania, we have the End of Life Options Act and the Pennsylvania Compassionate Assisted Death Act. And again, that would allow terminally ill patients who meet certain requirements to request life-ending medication. So do you see how that's different from a living will? A living will isn't saying it's okay to give me medicine that will kill me. It's just okay to stop all treatment. But assisted suicide is not legal anyway in Pennsylvania. It is legal in 1997. Oregon was the first state to allow physician-assisted suicide. Pennsylvania is not. New Jersey actually is. So it's important to know that distinction between these documents, that we can have a living will or advance directive. We could have a do not resuscitate, and we might even have some kind of assisted suicide something. And again, this is one of those things like abortion, where people on all sides of the story who believe a great deal in the advocacy of allowing this, and great advocacy for not allowing this. So that's something that, stay apprised as. It might be something that, as that's allowed, that gets added into the living will legislation or into your medical power of attorney. Something else that's really important that I don't always see in good medical power of attorneys is the ability for the medical power of attorney to work with the financial power of attorney to pay for care. So again, we've got lots of different legal documents that all do different things, but work together. So that's why you want to make sure that you have a comprehensive estate plan so that all the documents work together to, again, allow for a smooth transition of when you're making your own decisions to someone else making those decisions for you. So again, we talked about the history of living wills. We've talked about the most important cases to date, Supreme Court level and higher federal levels, for the authority to have something like a living will. We've talked about the importance of having a living will. We've talked about the simple component pieces to drafting a living will. We've even spent some time going through an actual living will, a statutory document here in Pennsylvania underneath the Pennsylvania Estate and Fiduciaries Code that shows us a sample of a living will, because the court system and our government believe these documents are helpful to get that decision away from the court system and back into the hands of your family members or your loved ones. And then I was explaining, just some information on things I've experienced on making sure you've got that document in place, where it's located. Some other interesting tidbits are, if you're divorced, here anyway in Pennsylvania, we have something that the person that you appoint is considered predeceased, as in that person's gone. But if you don't have a backup, then that living will isn't very helpful. Again, you want to make sure you talk about feeding and hydration, talk about whether or not it's okay to take that tube out, whether or not you want medicine to treat for pain or not, whether you want to donate your whole body, some of your body, none of your body. If you want that document to have to be read word for word, or do you want it to be informational purposes only? We understand that it's different different than a do not resuscitate. It's different than those assisted suicide documents and laws. The number one reason they don't work is people can't find them. But we want these documents in place so that we can end these family disputes by the bedside, like in the Terry Shivo case. We don't want to be condemned to a long, horrible, lingering death. We want this document in place so that we don't have to experience what Terry Shivo must have dealt with for 15 years before she was allowed to die a natural death. And then we've got some cases, which is, I do at least 5 of these a year where family doesn't have a medical power of attorney, doesn't have a living will. And we've got somebody in a car accident that's in a persistent vegetative state, and the hospital won't allow the ending of treatment. So the family has to hire me. We have to go to court, and the court has to make a final determination. Again, that takes time, that costs money, takes effort. And here we've just got a person sitting in a persistent vegetative state. So, I don't want any of you to be in that particular situation. Get these documents in place. They're really important. I know a lot of people say, well, if I'm out of it or if I passed away, what do I care? You do care. You care about your family members. You care about your friends. You care about your own life. I want the right decisions to be made about me by the people I want to make those decisions. My husband knows what I do and I don't want. My mom knows what I do and I don't want. Do you have somebody like that? Have you spent the time to talk to your family members about these end of life decisions and what you do or you don't want? Don't wait until you're in a coma after a car accident to talk about it, because you won't be able to. And again, these 3 cases anyway that I talked about were with people in their 20s. 1, don't drive a car too fast. 2, don't pop pills at a party. And 3, don't be bulimic. Might just be some background, some good life advice, but they should have had a plan in place. So when your child comes back from college is ending right now, is 18 years old, you might say, this kind of document planning, this is for elderly people when they're at the very end stage of their life. The answer is no. You should have these documents in place, and they should constantly be changing through the years. Every couple of years, you revisit those documents and go back to it. So I'm now going to ask our last trivia question. Let's see if somebody can get this right. Maybe there's somebody out there listening. If not, that's okay too. I have $50 more in my back pocket. But for a $50 gift card, I'm going to ask a question. Let's see if somebody can get this answer right. So I told us the story in the presentation, but which states, and you can put it in the Q&A section, which states here in the United States do not allow living wills? Which states here in the United States do not allow living wills? And while you're thinking of the answer, I'm going to share my screen again. I want you all to see a picture. And here we go. Let's see. So here we've got the poster girls for failing to prepare. We've got Karen and Quinlan. We've got Nancy Cruzen, and we've got Terry Shivo. Really important. Look like young, healthy, beautiful women. And they spent the last days of their life, I think anyway, in a condition that they didn't have to be in, and they probably shouldn't have been in. So just make sure that doesn't happen to you or your family members. And it looks like we've got somebody. So far the answer is not correct. So we have somebody who says there is a state here in the United States that doesn't allow living wills. So now remember, a living will is different than the assisted suicide. So the assisted suicide only has a small splattering of states. I want to say 6 or 7 here in the United States that allow that. Living wills here in the United States, it's a different answer. I'll give you one more try. It's a bit of a trick question, so maybe that'll tell you the answer. It's a little bit of a trick question. Which states here in the United States do not allow living wills? Trick question. See if we can get to that answer. Yay, we've got it. Awesome. So the answer is none. Here in the United States, since the late 90s, all states here in the United States allow it. So one, thank you for participating. We'll send you that $50 gift card. We're at the last couple of minutes of this webinar. I just want to thank you all so much for coming to these webinars, learning a little bit about estates, estate planning, trust administration. I can't tell you how many times my heart breaks when a family reaches out to me and doesn't have these things in place. And all I can think is, couldn't they just have spent a little bit of money, spend a little bit of time getting these things in order? Because now we're dealing with a really horrible situation. And hopefully, if you're on this, you'll hear that, you'll see that, you'll look back at your living will to make sure it says the things that it should, or you'll reach out to an attorney and get an estate plan in place. Or you'll reach out to friends, family members, children, and say, now I've heard these cases, you could get in a car accident, you could drink too much at a party, you could get stage 4 cancer. We are all going to pass away someday. How do we want those end moments of our life to go? And who do we want to get to make those decisions? I know for me, it's my family members, and I don't want to be kept in a persistent vegetative state indefinitely. And I'm guessing you don't either. So again, thanks for listening to me talk a little bit about living wills. I do these lunch and learns each and every month. If there's ever a topic that you want to hear about, certainly reach out to me. Hopefully you get some good nuggets of information. You can find me. My name is Whitney O'Reilly. I run our wealth preservation department here at Cohen Seglius. Type my name into the internet, shoot me an email, give our firm a call. We're happy to answer any questions for you, happy to review documents for you, talk a little bit more about living wills and their legislation. And again, just thank you for joining this presentation. We'll do it again sometime soon. You might find me in different spots. Today, I'm in my home office, but I go from state to state. So you'll see me in lots of different places. I hope you all have a wonderful rest of your day. And I hope at least the people on this webinar will have better planning moving forward, because you made the decision to spend some time listening to what could happen if I do or I don't have these kind of documents in place. Go get that living will and have a great rest of your day, everyone. Bye now. Again, it's Whitney O'Reilly signing off for the Wealth Preservation Department here at Cohen Seglius. Thanks, everybody.